Okay, so we've just gone past 3 o'clock. David, if you would like to kick us off.
Sure, many thanks, Ian. Well, welcome to this webinar on possession proceedings, residential leases. It'll be presented in the main, I'm glad to say, by my colleague Ian Cain. I'll be contributing, no doubt, unhelpfully from time to time with digressions and, as I say, no doubt, unhelpful observations about very excellent. Mr. Khan can't hear, apparently. I'll try and... Okay, sorry, Mr. Khan, I hope you can hear now. I hope that you'll enjoy this and find it informative. Ian prepared a really useful note on this subject, which will be sent out after the webinar is completed. As I say, Ian's going to, in the main, take you through the slideshow, and from time to time I will butt in with my unhelpful ad-libbed observations and digressions. So with no further introduction, I'll hand you over to Ian, who will now do what he has to do and do very well, I'm sure. Thanks, Ian.
Thank you very much, David. So just to add on to David's comments, as with all of the webinars that we've had during the course of our series, at the bottom of your screen, you will find the Q&A box. If you do have any questions whilst we're going through today's PowerPoint presentation, please do pop your questions into there, and David and I will be able to go through those at the end of the webinar and answer some of your questions that you have. Additionally, as David noted, both the slides from today's PowerPoint presentation, the practice note, and this video itself will all be uploaded onto Chambers' website within the news section. Additionally, you can go onto YouTube and just simply search for Goldsmith Chambers, and you'll find the Goldsmith Chambers page, where not only this webinar, but all of the webinars that we've had during the course of the series will be uploaded there. So moving on then, try that again. Unfortunately, my PowerPoint slides weren't working there. Oh, there we are. It's just a bit delayed.
We okay now?
Right, we are indeed. My apologies, everyone. Right, so the first thing that we really need to consider then is what is the current situation as a result of the coronavirus pandemic that we're unfortunately all having to go through at the moment. On the slide there, you'll see the two differing viewpoints of the current effect that COVID-19 is having in regards to landlords and tenants. The first quote is from the National Residential Landlords Association, in which they state that more and more landlords are contacting us saying their tenants are under the impression they no longer have to pay rent as a result of the current pandemic. But in response to that, the government, in their own guidance from the Ministry of Housing, Communities and Local Government, have said that tenants should continue to pay rent and abide by all other terms of their tenancy agreement to the best of their ability. Additionally, they go on to say, where tenants have difficulty paying rent over this period, we ask that landlords do not issue a notice seeking possession, particularly given that the tenant may be sick or facing other hardship due to COVID-19. So on the one hand, you've got landlords who are saying we're getting very concerned that some tenants seem to think they've currently got a rent holiday in which they don't need to be paying any of their rent. And on the other hand, you have the government telling landlords, well, even if your tenants are getting into a difficult situation at the moment, do not start bringing possession proceedings against them.
Okay,
So,
Ian, can I just butt in there, Ian?
Oh, of course.
Can I interrupt for a moment, Ian? Just with my cynical observation about purely and entirely personal point of view, and therefore almost certainly I'm wrong, but nonetheless, I'll just say this. I don't actually believe that many tenants do believe that they do not have to pay. I suspect that we can't take what the National Residential Landlords Association says about this as being a, shall we say, an entirely unbiased source of information. So I'm sceptical about whether tenants actually do pay, that they do not have to pay the rent. That's all I'd like to say. Go on.
I absolutely agree. And of course, it is only one viewpoint that we have at the moment from the landlord's perspective.
Sure.
But the question is, what have the government now decided to do as a result of their view that things are going to be difficult for tenants going forward? Well, as we've already discussed in our previous webinar, under Civil Procedure Rule Practice Direction 51Z2, all proceedings to enforce an order for possession by a warrant or a writ of possession are stayed for 90 days from the 27th of March 2020. Now, this was subsequently amended by Practice Direction 51ZA, which created an exception for an application for agreed case management directions. So the court have effectively said, we are not going to list any claims for possession in the county court. However, the parties themselves can still do what they can between themselves by negotiation and agreement to prepare themselves for when the restrictions are eventually lifted. Now, of course, there is the practice note up on the new section of Chamber's website, which deals specifically with Practice Direction 51Y, 51Z, and 51ZA. And if you've not already done so, I do urge you to go and check that out. Now, as many of you will remember from the last webinar where we focused on commercial leases, we have already seen the practice directions tested within the county courts in the case of Arkin and Marshall, in which the Court of Appeal determined that both practice directions were not made ultra vires and should be followed. The court, in theory, has the power to lift the stay, but this power is largely theoretical. And as you'll remember, the only example that they were able to put forward was one of serious public safety concern. And also, as per Practice Direction 51Z2A, parties can make an application for case management directions, which include dates within the stay period. The difficulty is going to be that if you are able to agree directions between the two parties, you're unlikely to be able to enforce them at the moment by a court order.
Right, Ian. So this agreeing case management directions obviously only really applies where you've got what you might call contested possession proceedings, where there are necessarily directions involving allocation to track and disclosure and witness statements, etc. So most possession proceedings that certainly I've seen, they don't tend to get involved in that sort of contested procedure, but where there are contested possession proceedings which involve the full paraphernalia of disclosure and witness statements, etc. Really, this is saying that that the parties can agree directions, but they don't need to follow them for the time being. It's up to can if they want, and if they don't want to, there's nothing that can be done about it. Is that the position, really?
Absolutely, and I completely agree with you. This is only really in those rare circumstances where the tenant is going to put forward some form of defence. In the majority of cases, it will be something to do with disrepair or challenging the very foundation of the case, in particular if it's brought on something like rent arrears. So moving forward then to consider the Coronavirus Act 2020. That received royal assent on the 25th of March 2020 and came into force from the 26th of March 2020. Most importantly, Schedule 29 of the Coronavirus Act 2020 increased the notice period for both Section 21 and Section 8 notices from whatever they would have usually been in the Civil Procedure Rules and the Housing Act up to 3 months. So considering for a moment Section 21 notices, you're jumping from 2 months notice required up to 3 months. And in some cases, that's a substantial jump when it comes to Section 8 notices, where you'd normally expect to only be required to give 14 days as a notice period. The provisions that have been imposed by the Coronavirus Act are not retrospective. That means if you've already served your Section 8 or Section 21 notice prior to the 26th of March, you don't need to reserve another one with the changed notice period. And the notice period within that notice will still be valid. The difficulty is then you will still get caught up within the stay that we currently have within the county court. Additionally, as you'll remember from the commercial lease webinar, the additional problem is, let's imagine that you got through the court process, an order for possession had already been made, the order for possession passes whilst we're in the middle of this stay period. Well, we're unfortunately in that difficult situation where enforcement agents now can't go to the property in order to carry out the order for possession eviction itself. And that's under the Taking Control of Goods and Certification of Enforcement Agents regulations from 2020. Therefore, you're in a difficult position where even if you've served your notice, you've got your order for possession, you're still not going to be able to get possession of the property. It really goes to show just how seriously the government are currently taking their standpoint that landlords should not be bringing proceedings against tenants, in particular as a result of outstanding rent arrears. David, is there anything you'd like to add at this stage before we move on to the back to basics approach?
Not at the moment, Ian. Thank you. No.
Excellent. So let's go right the way back to basics then and remind ourselves of some of the foundational points of residential possession proceedings. Because you should now be at the position where you're trying to get yourself ready for when these restrictions get lifted. So first of all, what is a residential occupier? Well, it's a person who occupies premises as residents by contract or by virtue of statute that entitles them to remain in occupation and restricts the right of any other person to recover possession. Section 1 of the Protection from Eviction Act makes it an offence to evict somebody from a residential property without a court order. This applies to those who have occupied the premises under a tenancy agreement or a licence. And it's particularly important to note that there are separate rules when it comes to trespassers. So let's look at the first approach in which most people will attempt to obtain that order for possession. We need to look at Section 8 of the Housing Act 1988, which sets out the procedure that a landlord can terminate the tenancy agreement during the course of the fixed term of that tenancy. However, it is crucial to note that the court shall not make an order for possession of a dwelling to take effect at a time when the AST is still within its fixed term, unless the ground for possession is on a mandatory ground, so mandatory grounds 2, 7, 7A, 7B, and ground 8, or any of the discretionary grounds from 10 to 15. So the majority of claims for possession will arise as a result of outstanding rent arrears. And the best grounds to use if there's outstanding rent arrears will be mandatory ground 8 and discretionary grounds 10 and 11. As you can see there on the slide, under mandatory ground 8, if at the date of service of the notice and at the date of the possession hearing, there is 8 weeks rent outstanding if rent is due weekly, 2 months rent is outstanding if it's paid monthly, and quarterly rent is more than 3 months in arrears, or at least 3 months rent is more than 3 months in arrears. If rent is due yearly, you can get a mandatory order for possession from the court. Now, the distinction between mandatory and discretionary is important because if you get a mandatory order for possession, it substantially reduces any opportunity for the tenant to fight against the order for possession once it's been made by the court. Because the judge is effectively saying, my hands are tied, I've got no choice, I have to make an order for possession. Additionally, you then have the discretionary grounds 10 and 11. Ground 10 being that some rent lawfully due from the tenant is unpaid at the date on which the proceedings for possession were begun and was in arrears at the date of service of the notice. And ground 11 then being whether or not any rent is in arrears on the date on which the proceedings for possession are begun, the tenant has persistently delayed paying rent or missed rent payments altogether previously, but have now brought themselves back up to the correct level. Now, grounds 10 and 11 are usually put forward in the alternative to ground 8, and there's nothing to stop you pleading all 3 grounds within your Section 8 notice, and we would encourage you to do so. In case there's anything that prevents the court from making a mandatory order for possession, they may well then wish to make a discretionary order for possession under grounds 10 and 11. Important to note that when we discuss rent, we're talking about rent that is lawfully due under the terms of the tenancy. That means that it has to be clearly outlined within the tenancy agreement, and the landlord must have provided their address for service of documents and payment of that rent to the tenant as well.
Yeah, Ian, that's sorry, just butt in there just with a couple of things. I mean, you quite rightly focused on assured tenancies under the Housing Act 1988, because more often than not, in terms of private residential tenancies, that is the form of tenancy that will exist, an assured tenancy. In fact, to be more precise, an assured short-hold tenancy. But there are still in existence old Rent Act protected tenancies. That's the Rent Act 1977. You still do occasionally encounter residential tenancies occupying their premises as Rent Act tenancies. And there is a slightly different, well, there is a very different process if the landlord wants to get possession. Things to watch out for. A, it is much harder in practice to obtain possession of a Rent Act protected tenancy. And secondly, as I recall, it is necessary for the landlord, first of all, to determine the contractual tenancy by giving notice to quit, which then, if the conditions are satisfied, creates a statutory tenancy under the Rent Act 1977. But only rarely will one encounter those old style Rent Act 1977 protected tenancies. The provision about in the 1988 Act for rent to be lawfully due, you're quite right to draw attention to that, because sometimes one does encounter cases where the landlord has failed to give the requisite notice under Section 48 of the Landlord and Tenants Act 1987. And I have seen claims for possession fail on that ground, that the possession's based on rent arrears, but because the Section 48 notice hadn't been provided, the rent wasn't lawfully due, and the claim for possession was unsuccessful. So you're quite right, attention to that potential pitfall for the unwary landlord in terms of proving the rent is lawfully due. Thanks, Ian.
Thank you, David. That is a very good interjection point as well, to note that during the course of the practice note, you'll see that we also discuss notices to quit as well. I urge you to have a look at that practice note as well, which explains in greater detail not only what we're discussing in today's webinar, but also some of the other issues in regards to the majority of residential tenancies. So going back then to our Section 8 notices and the other grounds upon which orders for possession can be sought. So if the tenant was to breach any of the other terms of the tenancy agreement, then that falls under ground 12. Specifically, if the tenant has done something which has caused significant damage to the property, you can seek an order for possession under ground 13, or the furnishings within it is covered by ground 15. For those unfortunate circumstances where there's alleged domestic violence complaints, you can seek an order for possession from the tenant under ground 14. And if the tenancy is tied into somebody's employment, such as it's a property in which somebody, going back some time, if you were in York, you worked at the Nestle factory, the Nestle company would often have properties in which they would put their employees into. If the employment was terminated, they would then want to get possession back of their properties. Going on to consider the actual format of Section 8 notices themselves, it's important to note that there are different prescribed forms for both England and Wales. So you need to ensure that you are using the correct form based on where the property itself is located. The Section 8 notice must specify the ground or grounds that are being relied on for possession, provide an explanation as to why each of those grounds is being relied on, inform the tenant that proceedings will not begin earlier than the date which is specified within the notice, and the proceedings will be brought within 12 months of the date of service of that notice. It's important to note there that where we say about specifying the grounds for possession, it's important that you copy and paste the exact wording of the grounds from the schedule. I certainly have seen a number of cases where Section 8 notices have been thrown out as a result of there being that issue. Of course, if you're serving a Section 8 notice and it's relying on rent arrears, you can use PCOL, which is the Possession Claim Online system. I went on the PCOL website earlier today, and there is a banner on their website stating that they will still allow you to issue proceedings on the PCOL website, but they will not be listed until that stay has been lifted. If you're using any of the other grounds which do not rely on rent, or you're relying on rent and some of the other grounds, then you're advised to use the CPR 55 procedure, which we'll come on to in a bit more detail in a moment. So let's move on then to consider Section 21 notices. So on or after the end of the fixed term of
Can
an
I just
AST.
go back to the Section 8 notice?
Yes,
sorry,
David.
Ian, because I saw a question from Shaf to all panelists, and I perhaps rather recklessly jumped in and said the answer is I would say you can serve a Section 8 notice and a Section 21 notice together. I'm pretty sure you can. I've seen that done. So that's that. But just on the Section 8 notice, the position, the strict position is this, apparently, that the full text of the ground for possession, as set out in the Housing Act, 88 Schedule 2, may not have to be repeated verbatim. But I'd agree it's probably safer to do so. And secondly, in terms of using the prescribed form, it is a very good idea. I've seen cases where the landlord or indeed the landlord's solicitor has used a form which is not in the prescribed form because it omitted essential information for the tenants. So you're quite right to emphasize it's safer to use the prescribed form and make sure it contains the prescribed information which is necessary to advise the tenant of their rights. Otherwise, the claim to possession could fail on the grounds of an invalid notice being served. Thanks, Ian. Sorry about that. Continue.
That's quite, no, that was a perfectly good point to interject. So going back then to Section 21 notices. So these are usually used once the fixed term of the assured short-hold tenancy has ended or the tenancy has moved into a new form of tenancy, be it statutory, periodic, or it's been extended through agreement between the two parties. So you can only use the Section 21 notice if no further AST exists other than the statutory periodic tenancy, and the landlord has given the tenant at least 2 months' notice that it requires possession of the property. Now you'll see that's in bold and underlined on the slide because of course that has now been increased right the way up to 3 months' notice being given under those Section 21 notices. Now if the tenancy agreement is an AST, it's written and the claim for possession is only in regards to getting possession of the property back, and you're not alleging any outstanding ground or breaches of the tenancy agreement, such as rent arrears, you can now use the accelerated possession procedure, in which you'd use the claim form N5A or N5B, depending on whether you're in England or Wales. Otherwise, the standard possession procedure that would be used is again covered under CPR 55. There are different requirements for Section 21 notices and you being able to serve them, depending on whether the property is based on England or Wales. So we'll look at those separately now. As my screen is now just being a bit slow, there we are. First of all, looking at the situation in England, which falls under the Housing Act 2004 and the Deregulation Act 2015. First of all, in regards to Section 21 notices in England, there is a prescribed form which has to be used in all cases, which is referred to as the Form 6A. That prescribed form is not applicable in Wales. The tenant has to have been served prior to the service of the Section 21 notice with an up-to-date energy performance certificate and a valid gas safety certificate. That doesn't mean you have to do that right before you serve the Section 21 notice. Usually it will be done right at the beginning of the tenancy and served with all of the tenancy documentation. The tenant has to have been served with the prescribed information about the rights and responsibilities of the landlord under the AST. This is often referred to as the How to Rent Guide. And the most recent version of that guide is from May 2019 and can be found freely on the government website. The deposit paid by the tenant must have been protected within a tenancy deposit scheme, and the landlord must comply with the initial requirements of that tenancy deposit scheme. In particular, that's in regards to serving the prescribed information. I sincerely hope that we are at the stage now where no landlords are not protecting their tenancy deposits, as of course a tenant can bring civil claims against you for failure to protect that deposit, and it can result in 3 times the amount of the tenancy deposit being paid out. If it's an applicable property in which a house in multiple occupation license or HMO license would be required, that license must be in place, and a selective license must be obtained if applicable. A selective license is one from the local housing authority. Different areas within even London alone require you to have specific licenses. The landlord must have returned any payment which cannot be charged by them as rent under the Tenant Fee Act 2019. In particular, that's in regards to things like agents' fees, which can no longer be recovered directly from the tenants and have to be paid by the landlord at the beginning of the tenancy. And finally, it cannot be a retaliatory eviction. What we mean by that is if, as a landlord, you've been served by a statutory repair notice by the local housing authority, that puts a bar on your ability to serve a Section 21 notice until they have been rectified. We're not going to go too much into detail on retaliatory evictions for the purposes of this webinar. Now, moving on then to look at...
So Ian, basically, sorry, Ian, yeah, so you finish this section and I'll say what I want to say. Just carry on a bit longer.
Thank you, David. So looking at the situation then in regards to Wales, as I said earlier, there's no prescribed form. You still have to comply with the tenancy deposit information and protection of it, and HMO licenses and selective licenses, because they're all covered under the Housing Act, which is applicable to both England and Wales. But you then have the additional considerations brought in by the Housing Wales Act 2016, to which a landlord has to be registered as a landlord and hold a required license to rent, or they have to use a managing agent who have that license and are licensed to rent properties. Additionally, as per we saw on the previous slide, slightly different legislation in regards to additional fees that could be claimed, and that's covered under the Rent Home Fees Act, etc., Wales Act 2019. David, you wanted to step in?
Yes, sorry, yeah. So what you've been saying, Ian, over these two previous slides is very interesting, because what it indicates really is that the Section 21 procedure is now extremely technical and technically demanding, I should say, in terms of the preliminary requirements for it to be a valid Section 21 notice. And it reinforces something that I've been thinking about for a while now, that being an amateur landlord is now an extremely dangerous thing to be, because you can very easily fall foul of these various requirements and directions, and it can be extremely costly for the landlord. So just one example I'll give you of this, Ian, the requirement to have a HMO license. Earlier this year, I dealt with a case at the first tier tribunal where Camden Council had inspected a property being rented by, I think, a number of students. And they advised the students that the property was a HMO and that their landlord didn't have the appropriate license. And they encouraged the students to make an application to the tribunal for a rent repayment order. And I'd never heard of one of those, I have to admit that, but it's quite draconian, and it resulted in this poor landlord having to repay to his tenants a very substantial chunk of the rent that he'd received from these tenants on the basis that he had not obtained the necessary license. So that the tenants had no complaint about their landlord whatsoever. And in fact, they got on very well with their landlord, but they got wind of this rent repayment order procedure and they took full advantage of it. And it was a very costly exercise for their landlord. So, and the tenancy deposit requirements are well known. And again, they are a potentially very expensive mistake for landlords to make. And it can be 3 times, of course, it can be many more times the deposit that can be the penalty. So being an amateur landlord now is very difficult. You need very good backup from solicitors and/or a very competent managing agent to help you to navigate your way through these requirements. Thank you.
Absolutely, I couldn't agree more with that. Ultimately, So let's move on to consider the actual procedure for bringing such claims. So first of all, in regards to service of the notice, usually your tenancy agreement will have specific reference as to how service is to be effected upon tenants. The most standard way will be by recorded delivery, first class post, or by hand service. Additionally, if you check the tenancy agreement and it's silent as to how notices can be served, usually the court will expect you to have served it by first class post, in person, or by recorded delivery. The other methods of service that you can use under CPR 6 usually can't be relied on unless specifically there is provision for it within the tenancy agreement. So, for example, you can't serve a notice by email unless the tenancy agreement says the tenant will accept service by email and an email address for service has been provided. It's very important to ensure that you keep proof of service. Usually this would be through a certificate of service once you have served that document. Also, if you've posted it, keep hold of any form of receipt that you have. Some people even go so far as to hold up a newspaper with the date on it as they're posting the notice through the door. Ultimately, if you've got a certificate of service signed by a statement of truth, the court will accept that as being adequate service. In terms of how you go about bringing the claim itself, you use the N5 claim form, and then the N119 particulars of claim is the pro forma setup for particulars of claim. You have to issue it within the county court unless there's a specific difficult issue of law or fact that will permit you to issue the claim in the High Court, and it will be the county court specifically in relation to the property itself. The easiest way to find out is to go onto the government court and tribunal finder website, type in the postcode for the property, highlight the fact that you're searching for ones which deal with possession cases, and you'll then be given your nearest court in which the claim itself should be issued in. Draw attention to a couple of sections from CPR 55, in particular CPR 55.71 and 4, because they produce slight peculiarities when it comes to possession proceedings. In particular, the tenant doesn't have to serve an acknowledgement of service, and most of the time you will turn up to the first hearing in the county court, you wouldn't have received an acknowledgement of service or a defence, and they will be raised at the door of the court. And CPR 55.74 states that the landlord cannot issue an application for default judgment if the defendant does not file or serve a defence for a claim for possession. So the court system will give the tenants the opportunities in order to respond to the claim as much as possible, given that most tenants, in particular those that find themselves in financial difficulties and can't pay their rent, won't have spare income to be able to pay for lawyers and legal representation. The court will usually make an order for possession in 14 days if it's made under any of the mandatory grounds under the Section 8 notice or a Section 21 notice. If it's brought under the discretionary grounds, the court can make an order for possession as it sees fit. That even includes making interim possession orders, where the court will say that if there's any further breaches of the tenancy agreement, the landlord can come back to court and an order for possession will be made. If a mandatory order for possession is made under the mandatory grounds under Section 8 or Section 21 notice, it's 14 days for the order for possession as standard. But under Section 89 of the Housing Act 1980, that can be extended up to 42 days. That will only be done if the tenant pleads exceptional hardship. So we now come on to the summary, effectively, of, well, what can you do now in order to prepare for the easing of restrictions? Well, first of all, decide which one of the two routes you want to go down, Section 21 or the Section 8 route. And you may also have to go down the route of considering notices to quit, which is outlined in more detail within our practice note. If you decide to go down the Section 8 route, you need to ensure that the notice is in the prescribed form from either England or Wales, and that the grounds are correctly set out and particularised within that notice. In Section 21 cases, if you're in England, make sure you're following the Housing Act 2004 and Deregulation Act 2015. In Wales, make sure you're following the Housing Act 2004 and the Housing Wales Act 2016. Bear in mind that from a practical point of view, what landlords can do is make sure they've done everything to be able to serve the Section 8 and Section 21 notices. You can go ahead and serve your notices, making sure that the notice does not expire within a 3-month period, whilst the restrictions are currently being imposed. If you're bringing a claim on TCOL, you can then issue the proceedings. You can issue the proceedings under CPR 55, or if you're using the accelerated possession procedure as well. But then that is where the claim will grind to a halt, and the court won't list the matter to be heard and an order for possession to be made until those restrictions are lifted. At the moment, it's that 90-day restriction, but there is, of course, the potential that it could be extended further depending on the most recent guidance from the government. So, thank you very much, everyone, for listening to that webinar. We're now at the stage where we'll take some of your questions. I understand that David has already been answering some of your questions as we went
Trying
through.
to, yeah.
The webinar today. So the first question that I have is someone has asked, well, what is exceptional hardship? Now, that is the million-dollar question, unfortunately. Exceptional hardship itself isn't actually defined within the legislation. The private example, I had one district judge who found exceptional hardship in a case where a child was about to sit their SATs exams in year 6, and they deemed that to be an exceptional circumstance. Whereas on the other hand, I've seen a judge refuse to find exceptional hardship when the tenant and the tenant's partner had effectively run out of money as a result of their son facing very serious criminal proceedings within the criminal court. And the judge didn't find that to be exceptional in the circumstances. Usually, in my experience, I find that if there's more than one factor which is put forward as being exceptional, it's much more likely that the court is going to find exceptional hardship. Because you question the word exceptional, it means something unique. It creates quite a high hurdle to get over. But it really does come down to the individual judge on the individual day.
Yeah, I'm not sure it has to be unique. It has to be exceptional. You think you're right, Ian. It's not an easy task for the tenant to bring himself within that discretion. So yeah, I agree, Ian. Yeah.
The problem is it's ultimately down to the judge to interpret what exceptional is based on circumstances that are presented to them. The different judges will reach those differing opinions. Someone else has asked, can you use Section 42 of the County Courts Act to transfer proceedings to the High Court for the purposes of enforcement? Now, for anyone who's not aware, that is in circumstances where you don't want to use the county court bailiff because perhaps they're facing exceptional delay and you want to get the matter moved up to the High Court so that you can use the High Court enforcement officers. Usually you need to have something exceptional about your case that would allow the court to move away from using the county court bailiffs, given that that's their entire purpose. They're supposed to enforce the orders made in the county court, to then move it up to the High Court itself. The difficulty is if you try using Section 42 of the County Court Act, once the restrictions are lifted, everyone's going to be in the same boat. You're going to find High Court enforcement officers and county court bailiffs are going to be swamped with enforcement opportunities for them to try and carry it out once the restrictions are lifted. Therefore, you may find it's not worth paying the additional amount of money to use the High Court enforcement officers compared to the county court bailiffs. Another question that has been asked.
Can I just say about? I agree with Ian. Just butt in with that. I think you're right about that. I remember being in front of District Judge Lightman at the County Court at Central London, and he's always very forthright in expressing his views about procedure and the courts generally, as you might know. And I'm pretty sure that he told me that the High Court was fed up with people trying to send up their county court possession orders for enforcement. But whether you can do that in practice, I don't know. But Judge Lightman was pretty clear in his advice. The High Court was not impressed by people trying to do that. But I don't know. Maybe you might have success.
I'm certainly aware that there are some instructing solicitors who will always ask for permission to transfer to the High Court. on the provision that if they then decide that it's not worth the transfer to the High Court, they can then just use the county court bailiffs. Another thing that really does vary from district judge to district judge, in my experience, as to how willing they are to move up. It also sometimes depends on which area you are in the UK, as some county court bailiffs are swamped and they're more likely to allow you to transfer it to the High Court. Others, they're not really running at that much of a delay and will keep it in the county courts. The next question I've got about is whether interest can still be claimed on rent arrears during the period in which that rent isn't being paid. The answer, quite simply, is yes. It depends on the terms of the tenancy agreement as to whether there's a fixed rate of interest. Otherwise, under the rules, it can be claimable up to a maximum of 8%. The problem is going to be if you're in a situation where someone doesn't have money, it's as a result of the coronavirus and they've been facing financial difficulty because they've lost their job, they've been furloughed, anything like that, you may well unfortunately find that the court will turn around and say, no, we're not going to award interest. It's important to note that costs and interest are always in the hands of the court to determine, even if your tenancy agreement says that there is a fixed rate of interest to be applied between the parties. David, do you have any other questions that have come in?
Gosh, no questions, Ian. That was excellent, I have to say, from my perspective. Really excellent. It's a very technical area of law, and only a few people can seriously claim to have a genuine expertise in the area. It's something that people have to keep checking on and checking up on to make sure they know what they're doing. I'm like that. And it's useful to have your very helpful note and these slides as well to point people in the right direction.
Thank you, David. Now, unfortunately, we've already run out of time, and thank you very much for sticking with us as we've already gone beyond the half-an-hour window. Again, as usual, if you do have any further questions after today's webinar, please do get in contact with our civil team clerks, Ben and Alice, on the details which are outlined on that final screen. Additionally, if you have found these webinars particularly useful and you would like a webinar that would assist your firm specifically, please do get in contact and we'll try and create a webinar specifically for you. The next civil team webinar will be on the 26th of May at the slightly later time of 4:30, and that's going to be health and safety in the context of employment law. Otherwise, please do come back and join us tomorrow at 3 p.m. for the family team, who will be taking us through Schedule 1 cases and a very brief introduction to them. Another reminder, these presentation slides, the practice notes, and this video will all be uploaded onto Chambers' website. Additionally, if you go onto YouTube, you'll be able to find Chambers' video uploaded onto the Goldsmiths Chambers account. Thank you ever so much for joining us. And
Ian, thank you.
We look forward to seeing you at the next webinar.
Fantastic. Thanks, Ian.